Case 1, Julie and Miller. April 17, 2024. Boone County Circuit Court, West Virginia. In the mountains of West Virginia, nestled deep in the hollows where the roads narrow and the houses sit far from the eyes of the outside world, children depend on the people who bring them into this life. They depend on them for food. They depend on them for shelter. They depend on them to be seen. In the hills of Boone County, community means something real. Neighbors know each other. Families have roots that go back generations. People look out for one another, or at least, that is the expectation. That is the unspoken agreement that holds small communities together through difficult times, through economic hardship, through the particular kind of isolation that deep Appalachian geography can create. But looking out for one another requires visibility. It requires that the people who need help are visible to the people who might provide it. And in the case you are about to hear, one 14-year-old girl had been made entirely invisible. Invisible to her school, invisible to her doctors, invisible to the neighbors, invisible to the state agencies that existed precisely to find children in situations like hers, for years. She had been withdrawn from the world so completely that when the day finally came that someone called for help on her behalf, it was already too late. Her name was Kennedy Miller. She was 14 years old. And the story of how one mother failed her, and how West Virginia's own child welfare system failed her alongside, is one that changed state law, prompted a federal audit, and sent shockwaves through the legislature in Charleston. On April 17, 2024, emergency responders were dispatched to a home in the Morrisvale area of Boone County, West Virginia. The call that brought them there was a cardiac arrest call. In Boone County, as in every corner of rural West Virginia, emergency responders travel roads that wind through hills and hollows, sometimes covering significant distances between a call and its location. They are trained to respond to the worst. They are trained to walk into difficult situations and maintain their composure, to focus on the work, to do what can be done. What they found when they arrived at that Morrisvale home tested that training in ways that none of them would easily forget. Kennedy Miller was found on the floor of a bathroom. She was 14 years old. She weighed 58 pounds. According to court documents filed in Boone County Circuit Court, her physical condition was described by investigators as skeletal. The word skeletal in a court document is not a word chosen carelessly. It is a clinical, legal descriptor. And it is the word that appears in the record of what emergency responders found on April 17, 2024, in that Morrisvale bathroom. Kennedy had not received medical care in at least 4 years. She had not attended public school since late 2019 or early 2020. Those who lived in the home told investigators that she had been homeschooled, but court records would later establish that her mother, Julie and Miller, had never submitted the academic assessments required under West Virginia law for homeschooled children. West Virginia state law requires that parents who choose to educate their children at home provide documented evidence of educational progress. That documentation did not exist for Kennedy. The assessments had not been submitted. The records were not there. According to those who were interviewed in the investigation that followed, Kennedy had left the home approximately 2 times in 4 years. 2 times. In 4 years. A 14-year-old child, living in the hills of Boone County, West Virginia, had seen the outside world twice in 4 years. Court records noted that a close family member told investigators that Kennedy had an eating disorder and had not been eating for months. But the Boone County prosecutor would later make clear to the court that whatever medical or psychological struggles Kennedy may have been experiencing, those struggles did not remove a parent's legal obligation to seek medical treatment for a minor child. A parent who witnesses a child deteriorating over months and years has a legal and moral obligation to call a doctor, to call an ambulance, to reach out to any one of the systems that exist to help children who are struggling. That obligation does not dissolve because the situation is difficult, or because the family prefers privacy, or because getting help would require acknowledging that something is badly wrong. Boone County Prosecutor Dan Hallstein stated publicly that Kennedy had spent the final days of her life alone on a bathroom floor. She was 14 years old, and she weighed 58 pounds, and no one in that home had called for help. Julie Miller was 51 years old at the time of her arrest. She was Kennedy's mother. 2 of Kennedy's grandparents, Jerry Stone and Donna Stone, were also residents of the Morrisvale home. The presence of 3 adults in that home makes the failure to seek help for Kennedy all the more staggering in its dimensions. This was not a child who was alone. This was not a child in a home with a single overwhelmed caregiver and no one else to turn to. There were 3 adults in that house. 3 people who watched. 3 people who knew what Kennedy looked like, what she weighed, how long it had been since she had received any kind of medical attention. 3 people who knew she was on that bathroom floor. In May of 2024, all 3 adults were arrested and charged with child neglect resulting in death. Law enforcement moved quickly. The evidence at the scene was not ambiguous. The physical state in which Kennedy was found told a story that the criminal charge reflected with precision. In September of 2024, a grand jury in Boone County Circuit Court reviewed the evidence and returned indictments against all 3 on the elevated charge of murder of a child by parent, guardian, or custodian by failure or refusal to supply necessities, along with child neglect resulting in death. The grand jury's decision to indict on the elevated murder charge reflected the seriousness with which the Boone County legal community viewed what had happened to Kennedy Miller. The case moved through the Boone County Circuit Court system over the months that followed. In November of 2025, Julian Miller entered a guilty plea to the charge of death of a child by parent, guardian, or custodian. By entering that plea, Miller acknowledged before the Boone County Circuit Court that her failure to provide necessities to her daughter had resulted in Kennedy's death. On February 25, 2026, Julian Miller appeared before Boone County Circuit Judge Stacy Nowicki Eldridge for sentencing. Judge Nowicki Eldridge had reviewed the photographs taken by investigators at the scene. She had reviewed the court records. She had read the documents that described what Kennedy looked like on April 17, 2024. The judge stated on the record that what she had reviewed was beyond her comprehension. She said that no child should ever endure what this child endured. She stated that this child had been deprived of the most basic necessities that a parent owes their child: food, medical care, and the simple acknowledgement that her life had value and that she deserved to be kept alive. Judge Nowicki Eldridge sentenced Julie and Miller to a minimum of 15 years in prison, with the possibility of parole. If parole is ever granted, the sentence mandates 50 years of supervised release to follow. 50 years. The length of that supervised release provision reflects the court's determination that Kennedy Miller's death was not an isolated moment of poor judgment, but the result of years of sustained neglect that continued right up to the day emergency responders walked through that door. At sentencing, Julian Miller addressed the court and expressed remorse. But the story did not end in that Boone County courtroom. Kennedy's death triggered a federal audit of West Virginia's child welfare system, an audit conducted by federal oversight authorities examining how the state investigates and responds to reports of child abuse and neglect. The results of that audit were alarming. Auditors found that the state had failed to comply with required standards in the vast majority of cases reviewed. In most cases examined, investigators had failed to conduct required interviews of children and adults in the home. In most cases, investigators had not adequately assessed immediate safety risks. The audit painted a picture of a child welfare system that was not functioning at the standard that federal requirements mandate. The findings landed with particular weight because the audit was not purely abstract. It existed against the backdrop of what had happened to Kennedy, and the backdrop included a specific, documented failure. Court records confirmed that West Virginia State Police had been called to check on Kennedy at the Morrisvale home in March of 2023, more than a year before her death. A state trooper responded to that call. The trooper spoke with people at the home. He noted no visible indication of abuse. He made an informal suggestion that mental health resources might be appropriate and left. No formal referral was made to Child Protective Services. No follow-up visit was scheduled. The trooper reported the girl appeared healthy. Kennedy told him she had anxiety about being around people following the COVID-19 pandemic. She was a child. She was sitting inside a home from which she had not emerged in years, and she gave the trooper an explanation, and the trooper accepted it, and he left, and no one came back. She had one more year to live at that point. 12 months. And no one came back. The intersection of Kennedy's case with the ongoing legislative debate about child welfare in West Virginia produced renewed momentum for a proposed measure known as Rayleigh's Law. Rayleigh's Law is named for 8-year-old Rayleigh Browning, who passed away in 2018 in West Virginia after being withdrawn from school while a pending child abuse investigation existed against her custodial parent. Rayleigh's law would place a temporary restriction on homeschool authorization when a parent is currently under an active child abuse or neglect investigation. The logic is straightforward. The decision to withdraw a child from public school removes the single, most consistent point of contact between that child and mandatory reporters, teachers, counselors, school nurses, who are legally required to report signs of abuse. Removing that contact during an active abuse investigation removes the most likely mechanism by which deterioration would be detected. As of early 2026, Rayleigh's law had not yet become law in West Virginia. The legislature had taken up the measure and debated it, but it had not crossed the finish line. Kennedi's name is now part of that debate. Her name, alongside Rayleigh's name, is being spoken in committee rooms and on the Senate floor in Charleston. She is invisible no longer. As of the time of Julie and Miller's sentencing, Kennedi's grandmother Donna Stone remains scheduled for trial on the charge of child neglect resulting in death, with a trial date set for March 17, 2026. Kennedi's grandfather, Jerry Stone, was found by the court to be incompetent to stand trial due to cognitive decline and was not prosecuted. There is a broader reckoning that Kennedi's case demands. It demands a reckoning with the question of how a child can be withdrawn from school, withdrawn from medical care, and withdrawn from all public contact for 4 years in the state of West Virginia without a single system successfully intervening. West Virginia has child protective services. It has mandatory reporting laws. It has school attendance requirements. It has homeschool documentation requirements. Every one of those systems was in place during the 4 years that Kennedi was disappearing, and every one of them failed to find her in time. That is the truth that the federal audit confirmed. That is the truth that the Boone County prosecutor spoke about publicly. That is the truth that Judge Noiki Eldridge acknowledged when she said what she had reviewed was beyond her comprehension. Kennedi's story is not only the story of one mother's failure. It is the story of what happens when every safety net has holes large enough for a child to fall through entirely. Kennedi Miller was 14 years old. She weighed 58 pounds. She spent her final days on a bathroom floor in Morrisvale, Boone County, West Virginia. And West Virginia is still working to become the state she deserved to live in. If you are concerned about a child's safety, please make that call. If this case moved you, please share this video so that Kennedi's story reaches people who need to hear it. Leave a comment below. Let us know what you think needs to change in West Virginia's child welfare system. And don't forget to like this video and subscribe to Cold Case Hour. Every case on this channel is fully sourced, court-verified, and documented, and we are here every week. Case 2, Lena Marie Lunsford-Conaway, September 23 to September 24, 2011, Lewis County Circuit Court, West Virginia. There are cases that test the endurance of an entire community. Cases where the waiting stretches on for years. Cases where a parent stands before cameras and asks the public for help finding a missing child, while investigators work quietly in the background, assembling the evidence that will eventually bring that same parent to trial. The case of Orellana Lunsford is one of those cases. From 2011 to 2018, the people of Lewis County waited. And when the verdict finally came, it carried the full weight of the law with it. Orellana Lunsford was 3 years old. She was reported missing on September 24, 2011, from her home in Lewis County, West Virginia. Her mother, Lena Marie Lunsford, told authorities that she had put Orellana to bed the previous night, that the child had been sick with a stomach ailment, and that when she woke the following morning, the little girl was simply gone. She said she had no idea what had happened. She said Orellana must have wandered out of the house. She said she did not know where her daughter was. Lewis County launched a search. Hundreds of volunteers walked the fields and woodlands around the Lunsford property. Law enforcement agencies from across central West Virginia participated. The search drew national media attention. Lena Lunsford appeared in front of television cameras. She wept. She asked for help. She said she just wanted her daughter back. Orellana was never found. What investigators found instead, over the following months and years, was a pattern of evidence that pointed away from the story Lena Lunsford had told. Court records filed in Lewis County Circuit Court would eventually detail what witnesses saw and what forensic analysis concluded. Investigators recovered evidence in and around the Lunsford home. 2 of Lena Lunsford's older daughters, who had been present in the home at the time of Ariel's disappearance, were interviewed by law enforcement. Their accounts, provided at different points during the investigation, would become central to the case that prosecutors ultimately built. According to testimony presented at trial, Ariel had been struck by her mother with a wooden bed slat on the night of September 23, 2011. Court records described the account given by the sisters, who stated that after the assault, Ariel stopped moving. Lena Lunsford then, according to their testimony, removed Ariel's body from the home and disposed of it in a wooded area. The following morning, she reported her daughter missing. Ariel's body was never recovered. Lena Marie Lunsford-Conaway, she had since remarried, was arrested in 2017 and charged in Lewis County Circuit Court with first-degree murder, death of a child by parent by child abuse resulting in serious physical injury, and concealment of a deceased human body. The trial began in April of 2018. Prosecutors built their case on the testimony of Ariel's sisters, on forensic evidence recovered from the home, and on the inconsistencies that had accumulated in Lunsford-Conaway's accounts over the years. The defense challenged the reliability of the sisters' testimony and maintained that Lunsford-Conaway had nothing to do with Ariel's disappearance. On April 23, 2018, the jury returned its verdict. Lena Marie Lunsford-Conaway was found guilty on all counts, including first-degree murder with no recommendation of mercy. On July 2, 2018, Lewis County Circuit Court sentenced Lena Marie Lunsford-Conaway to life in prison without the possibility of parole on the first-degree murder conviction, with an additional 40 years to be served consecutively on the remaining charges. The West Virginia Supreme Court of Appeals unanimously upheld the conviction in 2020. The court reviewed the evidence, the conduct of the trial, and the legal arguments raised on appeal, and found no basis for reversal. Ariel Lunsford's body has never been found. She has never been brought home. A headstone with her name exists as a memorial, but there is no grave beneath it. Somewhere in the woods of Lewis County, West Virginia, a little girl still lies where her mother left her more than a decade ago. Lewis County never forgot her. The volunteers who searched those fields in the autumn of 2011 never forgot her. And this channel will not forget her either. If Ariel's story matters to you, please share this video. Leave a comment below and let us know your thoughts on this case. And don't forget to like this video and subscribe to Cold Case Hour. Case 3, Ariel Bennett, November 7, 2015, Raleigh County Circuit Court, West Virginia. Not every case in the West Virginia court system involves premeditation. Not every case involves a long pattern of documented cruelty. Some cases arrive in a single devastating night, a night of choices made and chances missed, and leave behind consequences that no verdict can fully repair. The case of Ariel Bennett and her infant daughter Lynn is one of those cases. It is a case about neglect. It is a case about the legal standard that West Virginia holds parents to when it comes to the safety of infants in their care. And it is a case about what happens when that standard is not met. Lynn Bennett was 5 months old. On the night of November 7, 2015, Raleigh County Emergency Services responded to the home of Ariel Bennett in the Beckley area of Raleigh County, West Virginia. 5-month-old Lynn Bennett was found unresponsive. She was transported to a hospital, where she was pronounced dead. The investigation that followed established that Ariel Bennett had been severely intoxicated on the night of Lynn's death. Court records filed in Raleigh County Circuit Court noted that Bennett's blood alcohol level at the time relevant to the investigation was recorded at .289, nearly 3 times the legal limit for operating a motor vehicle in West Virginia. At that level of intoxication, a person's ability to perceive and respond to the environment around them is profoundly impaired. According to court records, Bennett had fallen asleep in a position that resulted in Lynn being suffocated. The medical examiner's findings were presented at trial, and the court heard testimony about the conditions inside the home on the night of Lynn's death. A pediatrician who testified in the case told the court that the living conditions he observed in the Bennett home were the worst he had encountered in decades of medical practice. There were 2 other children in the home at the time. Both were also found to be at risk. This gave rise to the additional charges of 2 counts of gross child neglect, creating substantial risk of serious injury or death, which were filed alongside the primary charge related to Lynn. Ariel Bennett was charged in Raleigh County Circuit Court with child neglect resulting in death and 2 counts of gross child neglect, creating substantial risk of serious injury or death. The case made its way through the Raleigh County Circuit Court system over the following years. In February of 2020, a jury found Ariel Bennett guilty. On July 16, 2020, 4.5 years after Lynn's death, Bennett was sentenced in Raleigh County Circuit Court. The court sentenced Ariel Bennett to a term of 5 to 25 years in a West Virginia correctional facility. In addition to the prison term, the judge ordered 50 years of supervised release to follow upon Bennett's release from custody. She was required to register on the West Virginia Child Abuse Registry for a period of 10 years. The court also imposed a fine of $11,000. The sentences on the 2 additional counts of gross child neglect were ordered to run concurrently with the primary sentence. Lynn Bennett was 5 months old when she died. She had been alive for 151 days. She had no ability to protect herself, no ability to call for help, and no ability to survive without the care and attentiveness of the adult who had brought her into the world. Raleigh County Circuit Court determined that the care she received on the night of November 7, 2015, fell catastrophically short of what the law requires. The West Virginia legal standard for child neglect resulting in death does not require intent to harm. It requires that a parent's failure to provide adequate care and supervision be the cause of a child's death. On those facts, the jury in Raleigh County was unanimous. Ariel Bennett remains in the custody of the West Virginia Division of Corrections and Rehabilitation, serving her sentence. Lynn Bennett will never know what she might have grown up to become. She deserved better. Raleigh County said so. The law said so. And this channel says so. If Lynn's story moved you, please leave a comment and let us know. Share this video with someone who needs to hear it. And don't forget to like this video and subscribe to Cold Case Hour. We will be here every week with cases that matter. Case 4, Krista and Brunecz. December 30th, 2022, Lewis County Circuit Court, West Virginia. There are cases where the facts themselves arrive with a weight that is almost impossible to process. Cases where investigators and prosecutors are required to walk into a courtroom and present evidence so profoundly disturbing that the formal, measured language of legal documents feels entirely inadequate to capture what actually happened. Cases where the legal system must simultaneously grapple with questions of accountability and questions of mental health, questions about psychiatric emergencies, about the point at which a person loses their connection to reality so completely that the law itself must find a different response than a prison sentence. The case of Krista and Brunecz, from Weston and Lewis County, West Virginia, is one of those cases. It is a case that shook Lewis County to its core on the final morning of 2022. It is a case that moved through the court system to a verdict that very few West Virginia cases ever reach. And it is a case that, even now in 2026, has not fully ended, because the woman at its center remains confined in a high-security psychiatric facility under the ongoing jurisdiction of the court. Weston, West Virginia, is the county seat of Lewis County, sitting in the heart of central West Virginia along the Staunton River. It is a small city with deep historical roots and the close-knit community character that defines much of rural Appalachia. It is a place where people know their neighbors, where families live close together in residential streets and apartment complexes, and where the events of December 30th, 2022, at the Weston Manor apartment complex would not remain quiet for long. On the morning of December 30th, 2022, Lewis County deputies were dispatched to the Weston Manor apartment complex in response to an emergency call. When they arrived, they found Krista and Brunecz holding her infant daughter. The infant was lifeless. Emergency medical services responded immediately. The infant was transported to Mon Health Stonewall Jackson Memorial Hospital. At approximately 8:14 in the morning on December 30th, 2022, the 3-month-old daughter of Krista and Brunecz was pronounced deceased at the hospital. She was 3 months old. The medical examination and autopsy that followed confirmed the cause and manner of the infant's passing. The autopsy findings documented that the infant's heart and lungs had been pierced by a knife. Both the infant and Brunecz herself had sustained stab wounds. Brunecz had been injured as well and required medical treatment. When Brunecz received medical care, She made admissions to both medical staff and investigators. According to court documents filed in Lewis County Circuit Court, she acknowledged that she had stabbed her infant daughter and had then stabbed herself. She stated that her intention had been that neither of them would survive. The infant did not survive. Law enforcement launched its investigation immediately. The baby's father, in the days that followed, spoke publicly about what he had witnessed in the period leading up to that morning. What he described painted a picture of a woman in the grip of a rapidly escalating psychiatric emergency. He told investigators and media that Brunecz had not been sleeping in the days before December 30th. He described thinking that had become erratic and entirely disconnected from the reality around her. He described behavioral changes so alarming that he had been actively trying to get her help. He stated clearly that he could see something was catastrophically wrong, and that he had been trying to reach intervention before it was too late. What he was describing is consistent with the recognized medical profile of postpartum psychosis, a rare, acute, and severe psychiatric emergency that can emerge within days or weeks of childbirth. Unlike postpartum depression, which exists on a broader spectrum and affects a larger population of new mothers, postpartum psychosis is a rapid-onset condition that medical literature consistently documents as capable of producing delusions, hallucinations, profound disorientation, and a complete severance from shared reality. It is classified as a psychiatric emergency requiring immediate hospitalization and intensive intervention. When it is recognized and treated in time, outcomes can be managed. When the gap between the onset of the crisis and the arrival of appropriate care is too wide, the consequences can be devastating for those closest to the person in crisis. In July of 2023, a Lewis County grand jury returned an indictment against Krista and Brunecz, charging her with murder and death of a child by a parent, guardian, or custodian by child abuse. The case then proceeded through Lewis County Circuit Court toward trial. On January 17, 2024, Judge Kurt Hall presided over the conclusion of the Lewis County Circuit Court proceedings in the case of Krista and Brunecz. After reviewing the evidence, the psychiatric evaluations, and the full legal record of the case, Judge Hall entered a verdict of not guilty by reason of mental illness. This verdict, not guilty by reason of mental illness, is one of the rarest outcomes in the West Virginia criminal justice system. It is not a finding that a person did not cause harm. It is a legal determination that at the time the act occurred, the person was suffering from a severe mental disease or defect that rendered them unable to appreciate the wrongfulness of their actions or to conform their conduct to the requirements of the law. It is a finding that the criminal justice system, having reviewed all of the evidence including the psychiatric evidence, has determined that prison is not the legally appropriate response, but that the person cannot be released into the community. Because of the not guilty by reason of mental illness verdict, Krista and Brunecz was not sentenced to a term of imprisonment. She was not released. Instead, she was placed under the jurisdiction of the Lewis County Circuit Court and the statewide Forensic Clinical Director of West Virginia, which is the state body responsible for overseeing the psychiatric treatment and ongoing evaluation of individuals found not guilty by reason of mental illness in West Virginia courts. She was committed to a high-security psychiatric facility. As of 2026, Krista and Brunecz remains in that high-security psychiatric facility. The case has not ended in the sense that a prison sentence ends when it is served or when parole is granted. Instead, it continues through a series of periodic court hearings, review hearings held before the Lewis County Circuit Court, in which mental health professionals present evaluations of her current psychiatric condition, her treatment progress, and their assessment of whether she continues to represent a danger to herself or to others. Hearings in her case were held in early 2025 and again in early 2026. At both hearings, the court reviewed the psychiatric evaluations submitted by the treatment team at the facility. At both hearings, the court found that Brunecz continues to represent a danger to herself or to others as a result of her ongoing mental health condition. At both hearings, the court determined that continued inpatient hospitalization in a high-security psychiatric setting remains the appropriate and legally required disposition. She remains confined. She remains under court jurisdiction. She is not free, and the court continues to review her case on a scheduled basis for the foreseeable future. The legal outcome in the Brunecz case is one that raises important and difficult questions questions that are worth examining seriously rather than dismissing. The not guilty by reason of mental illness verdict is not a loophole. It is not a technicality. It is a carefully constructed legal doctrine that reflects centuries of jurisprudential thought about the relationship between mental illness, moral culpability, and the purposes of the criminal justice system. The doctrine exists because society has long recognized that there are circumstances in which a person who causes profound harm was not, at the moment that harm occurred, capable of the kind of knowing, voluntary, morally culpable decision-making that criminal punishment is designed to address. Whether postpartum psychosis, at the severity documented in the Brunecz case, represents one of those circumstances is the question that Judge Kurt Hall answered on January 17, 2024. He answered it in the affirmative. The Lewis County Circuit Court, having reviewed all of the available evidence including the full psychiatric record, determined that it did. That determination does not diminish the loss at the center of this case. A 3-month-old infant passed on December 30th, 2022, in Weston, West Virginia. She was 3 months old. She had been in the world for a matter of weeks. She deserved the chance to grow, to develop, to become whoever she was going to become. Nothing about the legal outcome of the proceedings against her mother restores what was lost on that morning at Weston Manor. What the legal outcome does reflect is the West Virginia court system working with the full complexity of a case that demanded more than a simple verdict. It reflects a judge willing to engage seriously with psychiatric evidence. It reflects a legal doctrine applied in the rare circumstances where it is genuinely appropriate. And it reflects an ongoing commitment by the Lewis County Circuit Court to continue reviewing this case, reviewing it regularly, reviewing it carefully, to ensure that public safety remains protected even in the absence of a conventional prison sentence. The questions that this case raises about postpartum mental health infrastructure in West Virginia are as urgent as they have ever been. About screening protocols in hospitals and obstetric practices. About crisis response capacity in rural communities. About what partners and family members can do, and where they can turn when they recognize that someone they love is in acute psychiatric distress and the window for intervention is closing. These are not questions that the Lewis County Circuit Court can answer. They are questions for legislators, for health systems, for community mental health organizations, and for the people of West Virginia who deserve a state where a psychiatric emergency is met with rapid, effective intervention before tragedy occurs. The 988 Suicide and Crisis Lifeline is available by call or text 24 hours a day, 7 days a week. If you or someone you know is in a mental health crisis, please reach out. A 3-month-old child deserved to live. A court has spoken, and a woman remains in a high-security psychiatric facility in West Virginia, under court jurisdiction, with hearings scheduled to continue reviewing whether she will ever be safe to rejoin the world outside those walls. Leave a comment below with your thoughts on how the legal system handled this case. Share this video with someone who needs to understand the intersection of mental illness and the law. And don't forget to like this video and subscribe to Cold Case Hour. Case 5, Jeanne K. Whitefeather, between 2023 and 2025, Kanawha County Circuit Court, West Virginia. Some cases do not begin with a single night of violence. Some cases are built across years, constructed day by day, restriction by restriction, until a group of children who came into a home looking for safety find themselves living in conditions that the judge who sentenced their abuser would describe as hell. The case of Jeanne K. Whitefeather and her husband Donald Lance, from Sissonville in Kanawha County, West Virginia, is one of those cases. It is a case about the abuse of trust at the deepest level, the trust that children place in the adults who adopt them and call themselves their parents. And it is a case that resulted in one of the longest sentences ever handed down in a West Virginia courtroom. Jeanne K. Whitefeather and her husband Donald Lance adopted 5 black children from out of state. The children came to West Virginia through the foster care and adoption system, seeking the family and the stability and the love that adoption is supposed to provide. What they found in the Sissonville home was something else entirely. Court records filed in Kanawha County Circuit Court, along with testimony from witnesses, investigators, and the children themselves, documented what life was like inside that home over the period of the abuse. According to the evidence presented at trial and at sentencing, the children, 4 of the 5, were subjected to conditions and treatment that violated both West Virginia law and federal law, giving rise to charges under both state criminal statutes and federal civil rights provisions. The charges against Whitefeather included human trafficking, forced labor, child abuse and neglect, and civil rights violations. In total, she faced 35 counts. Court records documented that the children had been denied adequate food over extended periods. They had been denied appropriate medical care. They had been subjected to racial slurs in the home. They had been required to perform forced labor. At least 2 of the teenagers were found by neighbors locked inside a shed on the property that lacked adequate ventilation and temperature control. It was those neighbors who called law enforcement. When Kanawha County authorities responded and discovered what was happening inside that Sissonville property, the investigation that followed expanded quickly to involve both state and federal prosecutors. The scale and the nature of what had been done to these children who had come to West Virginia through adoption, who had no family nearby, who had no way to advocate for themselves, prompted federal involvement and a prosecution on charges that carried significant federal sentencing exposure alongside the state charges. On January 29, 2025, a jury in Kanawha County Circuit Court found Jeanne K. Whitefeather guilty on 31 of 35 counts. On March 19, 2025, Kanawha County Circuit Court convened for sentencing. The judge who presided over the sentencing addressed the courtroom before announcing the sentence. The judge made a statement that has been widely quoted in West Virginia media coverage of this case. Addressing Whitefeather and Lance directly, the judge said that they had brought these children to West Virginia, a place the judge described as almost heaven, and they had put them in hell. Jeanne K. Whitefeather was sentenced to 215 years in prison. The sentence represents the maximum allowable under West Virginia law for the charges of which she was convicted. The judge structured the sentence such that Whitefeather would not be eligible for parole consideration for 49 years. Her husband Donald Lance was sentenced separately and also received a substantial prison term. The 5 children who had been subjected to the conditions in that Sissonville home were removed from the residence and placed in appropriate care following the intervention by law enforcement. Their long-term well-being is not a matter of public court record, and this channel will not speculate about it. What is a matter of public record is that the Kanawha County court system, along with federal authorities, treated this case with the full seriousness it deserved. Jeanne K. Whitefeather was supposed to be a mother. She was supposed to be a protector. She was supposed to provide a home where 5 children could finally feel safe. Instead, she is now serving 215 years in a West Virginia correctional facility. And those 5 children survived, which in cases like this one, is the most important fact of all. If this case raised feelings for you, leave a comment below. Share this video with someone who needs to understand what the court system does when it works. And don't forget to like this video and subscribe to Cold Case Hour, justice documented every week. Case 6, Angel Talbert, November 16, 2024, Braxton County Circuit Court, West Virginia. Every now and then, a case arrives in the court system that raises questions so specific, so technical, and so devastating that they force the entire community to examine assumptions about what harm looks like and where it comes from. The case of Angel Talbert from Braxton County, West Virginia, is one of those cases. It began with the death of a 4-month-old infant. It led to charges of murder. And it moved through the Braxton County Circuit Court system through a process shaped by forensic science, legal argument, and ultimately, a guilty plea that resolved one of the most unusual cases in the county's recent history. On November 16, 2024, emergency responders were called to a home in the Gassaway area of Braxton County, West Virginia, in response to a call about an unresponsive infant. The 4-month-old daughter of Angel Talbert was found without vital signs and was pronounced dead. The infant's death triggered an immediate investigation by law enforcement and by the state medical examiner's office. The medical examiner's analysis of the infant's death produced a finding that shocked investigators. The toxicology examination revealed that the infant had an elevated level of ethanol in her system. The examination conducted at the medical examiner's level produced a liver ethanol reading that, according to expert testimony presented in Braxton County Circuit Court proceedings, was at a level that constituted a fatal dose for an infant of that age and size. The investigation that followed, conducted by West Virginia State Police and Braxton County law enforcement, led to the arrest of Angel Talbert and her partner. According to statements made in court records and reported in coverage of the case from West Virginia media outlets, both Talbert and her partner admitted to regularly applying a small amount of alcohol to the gums of the infant, a practice sometimes passed along informally as a home remedy for soothing a teething or fussy baby. Court records indicated that this had been done on an almost daily basis over a period of approximately 1 month prior to the infant's death. Medical and legal experts presented at the Braxton County proceedings established that the practice described is extraordinarily dangerous for infants. An infant's liver is not developed in a way that can metabolize ethanol the way an adult body can. Even small amounts that an adult might consider negligible can accumulate to toxic levels in an infant's system. According to the expert testimony cited in court records, the reading found in this infant was consistent with a fatal toxic accumulation over the described period. Angel Talbert and her partner were initially charged with murder and child neglect resulting in death. As the Braxton County Circuit Court proceedings progressed, the case encountered complications related to the handling and processing of the toxicology samples. Questions about the chain of custody and the integrity of the samples as collected and submitted for testing emerged during the pretrial phase of the proceedings. These are not unusual challenges in cases that depend heavily on forensic toxicology, and they are taken seriously by the court system because the integrity of forensic evidence is foundational to a fair prosecution. As a result of those legal complications, the case was resolved through a plea agreement. In approximately early 2026, both Talbert and her partner entered guilty pleas to the reduced charge of voluntary manslaughter. The sentencing under the plea agreement was pending at the time of this script's preparation. The child did not survive. She was 4 months old. She was entirely dependent on the adults in her home for every aspect of her survival. She had no ability to protect herself from a substance introduced into her body on a daily basis by the people responsible for her care. Braxton County Circuit Court is managing this case toward its resolution. The legal process exists precisely for situations like this one, situations where the truth is complicated, where forensic evidence requires careful handling, and where the court system must balance accuracy with accountability. The infant at the center of this case was 4 months old. Her name deserves to be remembered. Her life, brief as it was, deserved better. Share this video. Leave a comment. And don't forget to like this video and subscribe to Cold Case Hour. Case 7, Shannon Robinson, February 16, 2025, Taylor County Circuit Court, West Virginia. There are cases where the facts, once they become public, do not stay contained within the walls of a courtroom. They travel. They reach legislators. They force the people responsible for building and managing child protection systems to sit with what their systems failed to do. The case of Shannon Robinson from Grafton in Taylor County, West Virginia, is one of those cases. It is a case involving an 11-year-old child whose death in February of 2025 became a referendum on the state of West Virginia's child welfare infrastructure, and whose image was held up, literally, on the floor of the West Virginia State Senate. Lena Moran was 11 years old. On February 16, 2025, emergency services were called to a home in Grafton, Taylor County, West Virginia. Lena Moran was found unresponsive on the floor of the home's kitchen. She was 11 years old. She weighed 43 pounds. First responders transported Lena to a medical facility. She did not survive. The investigation launched by Taylor County law enforcement and West Virginia State Police in the hours and days that followed built a picture of Lena Moran's life inside that Grafton home. According to court records filed in Taylor County Circuit Court and reported by West Virginia media, including WBOY and WOWK, Lena had not received any medical care since approximately 2020, 5 years before her death. Witnesses who were interviewed by investigators described a pattern in which food was used as a form of discipline within the home. They stated that while other members of the household received full meals, Lena was subjected to food restriction as punishment. Lena weighed 43 pounds at the time of her death. She was 11 years old. For reference, the typical weight range for a healthy 11-year-old girl is approximately 70 to 100 pounds. Shannon Robinson was the child's stepmother. She was arrested and charged in Taylor County Circuit Court with murder of a child by a parent, guardian, or custodian, and child neglect resulting in death. A Taylor County grand jury returned an indictment against Robinson in January of 2026. As of the time of this script's preparation, the case in Taylor County Circuit Court was proceeding toward trial. What made Mianna Moran's case particularly significant within West Virginia's broader conversation about child welfare was not only the weight of the evidence against Robinson. It was the revelation that West Virginia's Child Protective Services system had visited the Grafton home on 4 to 5 separate occasions prior to Mianna's death. Each time, investigators closed out the case. Each time, Mianna remained in the home. A West Virginia state senator, moved by Mianna's story, stood on the floor of the Senate chamber and held a photograph of the 11-year-old girl for her colleagues to see. The senator made a direct appeal for legislative reform of the state's Child Protective Services response protocols. The image of a senator holding that photograph became one of the defining images of the 2025 legislative session in West Virginia. Child Protective Services in West Virginia has been the subject of ongoing legislative scrutiny for years, including in response to the Kennedy Miller case discussed earlier in this documentary. Mianna Moran's death added another name, another face, and another set of facts to that ongoing reckoning. The Taylor County Circuit Court process is continuing. Shannon Robinson has been charged, indicted, and is awaiting trial. The legal system is doing its work. Mianna Moran was 11 years old. She weighed 43 pounds. She had been seen by the child welfare system multiple times. And she was still in that house on February 16, 2025. West Virginia is still asking why. Share this video. Leave a comment and tell us what you think needs to change. And don't forget to like this video and subscribe to Cold Case Hour, because cases like Mianna's are why this channel exists. Case 8, Rebecca Lynn Hatcher, June 21, 2009, Logan County Circuit Court, West Virginia. The mountains of Logan County, West Virginia, have seen their share of tragedies over the decades. Located in the southwestern corner of the state, along the winding course of the Guyandotte River, Logan County is a community shaped by the coal industry, by tight-knit family networks, and by the kind of deep-rooted loyalty to place that defines much of rural Appalachia. It is also a county where, like every county in West Virginia, law enforcement and the courts are periodically called upon to confront the worst that human beings are capable of doing to those who are most vulnerable. On June 21, 2009, Logan County authorities responded to circumstances that set in motion a criminal investigation into the death of a child. The case that followed resulted in charges filed in Logan County Circuit Court against Rebecca Lynn Hatcher. The charge was child abuse resulting in death. Child abuse resulting in death is one of the most serious charges in the West Virginia Criminal Code. Under West Virginia law, the offense requires that a person who is a parent, guardian, or custodian of a child engage in abuse of that child, and that the abuse result in the child's death. The charge carries a potential sentence of not less than 3 nor more than 15 years of imprisonment, and the court retains the authority to impose additional penalties depending on the circumstances of the offense and the findings of the pre-sentencing investigation. The documentation available in this case from Logan County Circuit Court covers the charge and the jurisdiction. Logan County Circuit Court is the venue that handled the prosecution. The crime date is documented as June 21, 2009. The charge is documented as child abuse resulting in death. Logan County law enforcement and the Logan County Prosecutor's Office handled the investigation and the prosecution that followed. The Logan County Circuit Court system processed the legal proceedings. And the charge of child abuse resulting in death filed against Rebecca Lynn Hatcher reflects the determination of the Logan County grand jury that returned the indictment, a determination that the evidence presented to them met the legal threshold for that charge. Every case in this documentary represents a child. Every charge represents a life that was damaged or ended by the actions or failures of the adults who were responsible for that child's safety and care. The case filed in Logan County Circuit Court in 2009 against Rebecca Lynn Hatcher is no different. A child's death was investigated. A charge was brought. The legal system in Logan County took the responsibility of that case seriously. In Logan County, as in every county in this state and in this country, the charge of child abuse resulting in death is never treated as anything less than what it is, a case about the loss of a child who deserved to be protected. The work that law enforcement officers, investigators, prosecutors, and court personnel do when they take on these cases, in Logan County, in Boone County, in Lewis County, in every county in West Virginia, is work that is done in the name of children who can no longer speak for themselves. That work matters. It always matters. Share this video. Leave a comment. And don't forget to like this video and subscribe to Cold Case Hour. Case 9, Oreanna Antoinette Myers, December 8, 2020, Greenbrier County, West Virginia. Some cases do not proceed to trial. Some cases are resolved not by a jury verdict or a judge's sentence, but by the final act of the person responsible. These cases are, in many ways, among the most difficult to process, because there is no courtroom, no cross-examination, no moment where a jury looks at the defendant and delivers the word that communities need to hear. What remains instead is only the evidence, the investigation, the medical examiner's report, and the grief of a community left to make sense of something that resists making sense. On December 8, 2020, Greenbrier County authorities were called to a residence in Williamsburg, a small community in Greenbrier County, West Virginia. What they found at that residence constituted the deadliest mass shooting in the recorded history of the state of West Virginia. Oreanna Antoinette Myers was 25 years old. She lived in the home with 5 children, 3 biological sons, and 2 stepsons. The children ranged in age from 1 year old to 7 years old. Their names were Aiden, Orion, Silas, Colt, and Aiden. According to the investigation conducted by the Greenbrier County Sheriff's Office and the West Virginia State Fire Marshal's Office, Myers shot all 5 children inside the home with a single-shot .410 shotgun on the night of December 8, 2020. She then set the home on fire. She then took her own life outside the residence. All 5 children died. The West Virginia State Fire Marshal determined that the fire was deliberately set, a finding of arson. The Greenbrier County Medical Examiner ruled the deaths of all 5 children homicides and the death of Oreanna Myers a suicide. Investigators who responded to the scene and who conducted the investigation in the days that followed found written notes that Myers had left. Those notes referenced a mental health crisis. Those notes referenced beliefs and fears that pointed toward a profound psychological deterioration in the period leading up to December 8. Myers had, by all documented accounts, been struggling. The nature and the depth of that struggle, and whether adequate mental health resources were available or accessible to her in the weeks and months before December 8, are questions that the Greenbrier County community and mental health advocates across West Virginia have been wrestling with since the night the fire was set. West Virginia is a state that, by many measures, faces some of the most significant mental health access challenges in the country. Rural communities like Williamsburg are often located far from psychiatric hospitals, inpatient facilities, and crisis intervention services. The distance between a person in crisis and the help they need is sometimes measured not in willingness but in miles and available resources. None of that context removes the weight of what happened on December 8, 2020. 5 children died. 5 children, ages 1 to 7, who had no understanding of the crisis around them, who had no ability to protect themselves, and who deserved the chance to grow up, to go to school, to become whoever they were going to become. Aiden, Orion, Silas, Colt, Aiden. The Greenbrier County community mourned. The state of West Virginia mourned. And the questions about mental health access, crisis intervention, and the gap between a person reaching the breaking point and a system that can catch them before they fall, those questions remain open. No trial was held. No sentence was imposed. The legal process ended on December 8, 2020, outside a burning house in Williamsburg, Greenbrier County, West Virginia. If you or someone you know is in a mental health crisis, please reach out to the 988 Suicide and Crisis Lifeline by calling or texting 988. Help is available. Share this video. Leave a comment. And don't forget to like this video and subscribe to Cold Case Hour. Case 10, Julie and Orellana, September 20th, 2018, Berkeley County Circuit Court, West Virginia. Some verdicts arrive after weeks of deliberation. Some juries agonize over questions of intent, over competing interpretations of evidence, over whether the facts meet the precise legal threshold required for a conviction. And some cases go to a jury that deliberates for under 4 hours, not because they were in a hurry, and not because they treated the gravity of the decision before them lightly, but because when the evidence has been presented completely, when every witness has testified and every document has been entered into the record, there are cases where the truth is as clear as anything a jury room has ever seen. The case of Julie and Orellana from Gerardstown in Berkeley County, West Virginia, produced one of those verdicts. It also produced testimony from an 11-year-old girl that no one who heard it in that Berkeley County courtroom will ever forget. Berkeley County occupies West Virginia's eastern panhandle, a narrow finger of land between Maryland to the north and Virginia to the south. Martinsburg is the county seat. Gerardstown is a small community a few miles to the west, in the rolling farmland that characterizes this corner of the state. It is a place of open sky and quiet roads, a place that in the autumn of 2018 had no reason to expect that one of the most carefully documented and devastating criminal cases in Berkeley County's recent history was about to unfold inside a house on a residential street. Julie and Orellana was the mother of 2 daughters. Eliza was 8 years old. Olivia was 11 years old. They were sisters. They lived together in the family home in Gerardstown. They were, by all accounts, children living the kind of childhood that children in places like Gerardstown live, going to school, coming home, occupying the space of their everyday lives in the way that children do when they do not yet know how quickly the ordinary can be taken from them. On September 20th, 2018, what had been ordinary ended. According to court records filed in Berkeley County Circuit Court and testimony presented at trial, on that evening Julie and Orellana told her 2 daughters to go upstairs and look for kittens under a bed in a bedroom. Both girls went. They were children being told by their mother that there were kittens to find. They went to look. Orellana had purchased a firearm the day before. She opened fire in that upstairs bedroom. Both girls were struck. 8-year-old Eliza was hit. 11-year-old Olivia was shot in the leg. According to the forensic findings of the Berkeley County Medical Examiner and the testimony presented at trial, the attack on Eliza did not end with the gunshot. The medical examiner's findings documented that Eliza had also been stabbed 35 times. Eliza was 8 years old. She did not survive. Olivia, shot in the leg, did something extraordinary. She got up. She moved. She got herself out of that bedroom. She got out of the house. She made it to a neighbor. She told them what had happened. She called for help. Because Olivia ran, Olivia survived. Berkeley County law enforcement responded and took Julie and Orellana into custody. In the moments following her arrest, Orellana was informed that Olivia had survived. According to testimony presented at the Berkeley County Circuit Court trial, Orellana responded to that information by stating that they were all supposed to pass away. Investigators found a 6-page letter that Orellana had written to her ex-husband. The letter was recovered and introduced into evidence at trial. The content of that letter, combined with the documentation of the firearm purchase on the day before the attack, established a degree of premeditation that the Berkeley County jury would weigh carefully as they deliberated. Julie and Orellana was charged in Berkeley County Circuit Court with first-degree murder in the passing of Eliza and first-degree attempted murder in the attack on Olivia. The trial proceeded in January of 2020. The Berkeley County courtroom heard the evidence, the forensic findings of the medical examiner, the documentation of the firearm purchase, the 6-page letter, the testimony of law enforcement officers who responded to the scene. And the courtroom heard from Olivia. Olivia was now a teenager at the time of the trial, several years removed from the night of September 20th, 2018. She had been shot in the leg. She had watched her sister not survive. She had escaped through a window and run for help. And she came to Berkeley County Circuit Court, and she testified. She answered the questions that the prosecution needed her to answer. She told the jury what she had seen and heard and experienced on the worst night of her life. She was a child who had survived something unsurvivable, and she came back to make sure the record was complete. On January 9th, 2020, the proceedings moved toward their conclusion, with Orellana having been found guilty. The case proceeded to the sentencing phase. At sentencing, the jury was asked to consider whether to recommend mercy, a question that, under West Virginia law, directly determines whether a life sentence for first-degree murder includes or excludes the possibility of parole. A recommendation of mercy means the possibility of parole exists. A recommendation of no mercy means it does not. The jury deliberated for under 4 hours. They returned a recommendation of no mercy. On February 7, 2020, Berkeley County Circuit Court sentenced Julie and Orellana to life in prison without the possibility of parole for the first-degree murder of Eliza. Additional consecutive sentencing was imposed for the attempted murder of Olivia. Under 4 hours. The jury deliberated for under 4 hours on a question that would determine whether Julie and Orellana would ever again be free. They came back with their answer in under 4 hours. The Berkeley County legal system had done its work. Law enforcement had responded, documented, and investigated. The prosecutor's office had built the case, presented the evidence, and made the argument for accountability. The jury had listened to all of it, including Olivia's testimony, and had deliberated and returned a verdict. The judge had imposed the sentence. Life without the possibility of parole. That is what Berkeley County Circuit Court determined was the appropriate consequence for what happened in a house in Gerardstown on September 20th, 2018. Eliza was 8 years old. She was looking for kittens when her mother opened fire. She was 8 years old, and she was looking for kittens, and she did not survive. Olivia was 11 years old. She was shot, and she ran. She got out. She got help. She came back to that Berkeley County courtroom years later, and she testified. She made sure that what happened to her sister was on the record. She is one of the most remarkable people in any case on this channel. An 11-year-old child who, in the most terrifying moment of her life, found a way to survive, and who then found the courage to come back and face it all over again in the service of justice. Olivia's survival means that Eliza's story was told completely. It means that the Berkeley County jury heard from someone who was there. It means that justice was done in part because an 11-year-old girl refused to let what happened be buried with her sister. That is what survival means. That is what courage looks like when it is 11 years old and has a bullet wound in its leg and walks into a courtroom anyway. To every person who stayed through all 10 cases in this documentary, thank you. These are not easy stories. They are stories of children who were harmed by the people who were supposed to protect them. They are stories of systems that failed and systems that worked. They are stories of communities that grieved and courts that held people accountable and survivors who testified and juries who listened and judges who imposed the sentences that the law provides. They are stories that matter because the children at their center matter. Kennedy, Alia, Grace Lynn, the infant in Braxton County, Mianna, the child in Logan County, Aiden, Orion, Silas, Colt, and Aiden, Eliza. Every single one of them deserved better. Every single one of them deserved to be protected, to be seen, to be kept safe. Most of them were not. But they are seen now. They are documented now. Their names are in the record, and on this channel, their names will not be forgotten. West Virginia's courts have spoken in most of these cases. In the cases still making their way through the system, West Virginia's courts will speak in time. The law is not always fast. But case after case, county after county, across the mountains and the valleys and the hollows of this state, it arrives. It does its work. And it speaks in the name of children who can no longer speak for themselves. If this documentary mattered to you, please share it. Leave a comment telling us the name of the child in this documentary that you will carry with you. Every comment, every share, every subscription helps this channel do the work of keeping these stories in front of the people who need to hear them. Don't forget to like this video and subscribe to Cold Case Hour, new fully sourced, court-verified documentaries every week. We will be here, and we will keep saying their names.